Welcome, everyone, to our panel discussion on some legal aspects around the current situation in Ukraine. Thanks for joining us, and we hope that we together can make at least some sense of the horrifying events that we're seeing. Allow me a couple of introductory remarks before we begin our discussion with our panelists. Russia's invasion of Ukraine has put an end to the promise of peace in Europe, and it has rippled the fundamental fabric the world knitted after World War II. Russia's aggression against Ukraine is not only a blatant and completely unjustifiable violation of international law, in particular those legal norms of the United Nations, but it's also a slap in the face of the international moral order, if you will. Post-World War II generations have lived in a world that was built on the inherent premise that peace is the common goal of all states. And we have now often heard that in this regard, the audacity of Putin's aggression might indicate a Zeitenwende. As international lawyers, we have found ourselves in a state of shock ever since the 24th of February. The relevance of our entire discipline is being called into question, it feels. And we may not have answers yet, but we also didn't want to remain speechless in the face of the events. And instead, we want to share our thoughts with you and discuss perspectives and frustrations regarding international law amongst each other and with you, the audience. While the invasion of Ukraine is horrible, the reaction of the international community gives some hope. Russia has come under intense scrutiny of international institutions, and it has faced strong backlash by a large number of states. Moreover, there have been strong answers of civil society and corporations that have played a meaningful part in upholding the validity claim of international law. And while courts have in the past often been viewed as toothless tigers, states and individuals have turned to them for help in creative ways. So these and other aspects are those aspects that we want to discuss in the following minute. But we do not want to do that only amongst ourselves, but we want to do that together with you, the audience. So we will initiate our conversation by starting with some brief inputs by our experts on the panel. We want to share with you what moves us and what our current thoughts are on the aspects that we're discussing. And then we will open up the sessions to questions from the audience. And we very much encourage you to already as we go post questions in the chat and the Q&A function so that we can collect them and post them to the audience as we go. So we will begin by looking at the role that courts play. We have seen applications against Russia in the context of the aggression against Ukraine with international and regional fora. The two international courts that have become involved and that we want to focus on today are the ICJ and the ICC. The interstate proceedings between Ukraine and Russia before the ICJ have been brought by Ukraine based on the Genocide Convention, and the investigation at the ICC has been initiated by the prosecutor there on the or after applications by member states to the Rome Statute, such as Lithuania. Both of these can be described as creative ways to bring the situation before courts because none of them addresses the question of the illegality of the use of force directly. But they are nevertheless potentially meaningful, and we therefore want to discuss them with Pierre Thielberger. Pierre is a professor of public law and public international law at Ruhr-Universität Bochum, and he's the executive director of our institute, the Institute for International Law of Peace and Armed Conflict, the IFHV here in Bochum. Pierre, generally speaking, what is the role of international courts in addressing international conflicts like the one between Russia and Ukraine?
I would say it's largely overestimated, to be honest. That would be my answer. It's little. I mean, you have just spoken that it gives hope, the reactions that we saw by civil society, by corporations. But, you know, it's not very hopeful if we look at the reaction that Russia has given so far. And just to give one example, you mentioned already the ICJ proceedings that have started yesterday. Russia didn't even show up, you know. So I don't know. I think it's it's a trap for us international lawyers to always look to courts and say, yeah, they are the solution to the problem. And I think they are not, to be very frank. I mean, even in the case, and I'm sure we'll discuss that later, this proceeding for provisional measures is going the Ukrainian way, which is not sure, but if it does, even if we have such an order, I mean, Russia is not very likely to comply with it. So I think we have to first reality check of the afternoon. Courts are not the answer.
But while they are not the answer, and I guess people in this webinar will agree with you on that, but we nevertheless have this case there. So the preliminary hearings have started yesterday, and what is your view on what these proceedings can contribute in tackling this situation, although the contribution will most certainly be limited?
Yeah, I mean, it attracts a lot of attention, media attention. That to start with that, of course, we're discussing it now. I've had a lot of media questions about it over the last weeks. So it's obviously something that people talk about. And I would give the Ukrainian side that it's a very, as you already said, Bene, a very creative way. I remember very well when being asked like 10 days ago whether such a procedure would be possible, my answer was no. Because, there would be no jurisdiction because the Russians would not agree to it. And this, I have to say, when I first read the Twitter by the Ukrainian president, I was already thinking, oh, wow, this is going to go along the lines of the Genocide Convention. And that was, I think, very interesting. So, I mean, you've said already, this is not a case about whether the aggression or whether there was an aggression of Russia against Ukrainian territory. This is the question whether or not there is a potential violation of the Genocide Convention. Because as you remember, one of the justifications that was given by Vladimir Putin was that there was an ongoing genocide happening in eastern Ukraine against Russians or ethnically Russian people, and that therefore there was a humanitarian intervention need, if you like, to intervene. And so it's kind of funny, actually, this was used by the Russians as an example, as a justification that's why they had to invade. That's why they had to do a humanitarian intervention. And now this is kind of, used against them by the Ukrainians. I think there's a certain irony in this that I quite enjoy, I have to admit. And of course, so we have now provisional measures. And essentially, three things are difficult here, or three things have to be shown by the Ukrainians, right? The first thing, and that's probably the biggest problem, is jurisdiction, right? Because, of course, under the classical ways of Article 36 of the ICJ statute, you would think, okay, the two parties haven't given this conflict to the ICJ, and there is no general, 36 paragraph 2 declaration. So how is it going to go? It can only go via a clause in a treaty. Right. And in the literature, you've seen several proposals for this. Some of them were then withdrawn. However, I think this one is the one that we're dealing with now. And under Article 9 of the Genocide Convention of 1948, you have this clause that disputes between members to the Genocide Convention, with both states can be dealt with by the ICJ, and that's now happening. But of course, it is a stretch or a creative way of finding jurisdiction. And I think this is the first hurdle that has to stand. I would say in a normal case, I'm not sure how the ICJ would decide. However, of course, you cannot neglect the political environment here, that the ICJ probably wants to decide on the case. And so I would be rather optimistic whether this jurisdictional trick, I shall say, that the Ukrainians have found might maybe stand. Then the second one is, of course, plausibility, right? Whether the accusations that is made here is plausible. So what could it be? It could be, and it has been outlined by the Ukrainians by now, that first of all, they were wrongly accused of a genocide, and that the Russian side actually, with the invasion, also follows a genocidal aim, right, which has also been claimed. So we'll see which of the two will actually be convincing, if any, and whether then, the claimed rights are plausibly violated. Yeah, and then the last part is whether there is a damage that has to be kind of prevented, the irreplaceable prejudice. So whether or not, if the provisional measures following Article 41 are not granted, whether there is a damage that cannot later on be healed, if you like. And of course, I think on that point, there isn't much to argue. I think there's an ongoing war, people are dying, infrastructure is destroyed, the political system is breaking down. I mean, that there will be a damage if there isn't the order to sustain the military activity. I think that part will be easy for the judges to decide. So we'll have to see. I think the biggest hurdle, as I said, is the jurisdiction, because it is, as you said, creative. If I was a Russian lawyer for the Russians, just for the sake of argument, please, yes, I would say this might be not in good faith, because clearly this dispute is not about what was meant by Article 9 of the Genocide Convention. But then again, it would also be in this situation quite a stretch for the Russians to rely on good faith. So,
and do you see other ways that the ICJ could pronounce something on that matter? And I don't mean rule in the sense of a judgment, but is there perhaps an avenue for an advisory opinion given by the ICJ?
Yes, I mean, it has also been discussed. I don't know really whether that will happen or not. There is, of course, the possibility that the General Assembly decides to hand this matter to the International Court of Justice. And I think the interesting question then, Benedict, would be, what is actually the question that is asked, right? So first of all, of course, advisory opinion, not legally binding and so on. But what is actually the question that's asked? I think two could be thinkable. One is whether the the invasion, or whether let's say, the actions of Russia qualify as an aggression against Ukraine. That's the obvious question that could be asked. And the second question could also be asked, I think, which has been discussed, is whether the behavior of the Russians in the Security Council to veto the resolutions that were suggested, whether that could be abuse of rights, right? And both of them, I think, have problems. If the first question is the question in an advisory opinion, this is really not what an advisory opinion is about, right? I mean, an advisory opinion is about more or less a general matter that needs to be decided, or on which the General Assembly would like to have an opinion of the International Court of Justice. But what this advisory opinion would do is try to replace a jurisdiction that is otherwise not there, right? So if you have a contentious case and then say, okay, I don't have jurisdiction, so I'll just ask the General Assembly to get me an advisory opinion, that's not what an advisory opinion is for, right? So that's the first problem with that proposal. And the second one, whether the Russians were actually so free to veto the resolution against them. I'm quite surprised about this proposal, because I think the answer might not be one to our liking. I mean, a lot of people argue that the P5 are very free in how they exercise their special responsibility for the maintenance of international peace and security. And whether in some way or not, this can be construed that the Russians have misbehaved also in the way they behaved in the Security Council, I'm not so sure about that. So there is the option, I think, depending on which question is asked, but both avenues also have problems.
And what about, Pierre, the other court that the public has pinned high hopes on? I mean, there has been a lot of calls for Putin to be put before a bench in The Hague. And what is meant by that is, of course, the International Criminal Court in The Hague, the ICC. How do you evaluate the chances of Putin actually being tried before the court one day? I mean, certainly not in the foreseeable future, but one day.
Low, I would also say. I mean, I'm very pessimistic today, I know, but I mean, so step by step. So you have the 4 core crimes, right? And the obvious one that would apply to Mr. Putin would be the crime of aggression, right? The relatively new crime of aggression that was later on included in the Rome Statute. And the problem with that, following Article 15 of the Rome Statute, is, of course, that you either need both involved parties. So Ukraine and Russia in this case would have to be a member to the Rome Statute, or you need a Security Council resolution to give the case to the ICC, and both is not feasible, right? So that's why the crime of aggression is not going to be an option. So what you are in truth then speaking about is crimes against humanity and war crimes. for which, if we believe the prosecutor, there is probably enough evidence. But that, of course, is not tailored to Mr. Putin, right? That is tailored to the soldiers, to the combatants on the grounds. And then to create the link that we would need for this so that we can try Mr. Putin also for crimes against humanity and war crimes is not going to be so easy, I would say. I'm not going to say it can happen, but it would be quite a stretch. And then, of course, the other question is, will ever, even if we had a case against him, will he ever appear in The Hague, right? And that's the problem that we know from many other heads of states. Think about al-Bashir, right, where we have waited for this and we're still waiting for this. However, things can change if the political situation changes. So if we have a political change in Russia and a new government would be willing to, cooperate with the ICC, then there could be an option for this. But I don't know whether this is currently very likely. Maybe to at least say also something positive. You already mentioned Lithuania's involvement in this. It's not only Lithuania, right? I think it's more than 30 states or so who have done this. So in general, there is quite a high willingness to cooperate by other states on the case. So in terms of gathering evidence, in terms of I don't know what kind of help we can imagine, there might be a lot of willingness by other states, but the problem is there won't be any willingness by the Russians. And unless we have a political change in Russia, I don't actually see him being transferred to The Hague.
Okay, thank you. Thank you very, very much, Pierre, on your input on the role that the two courts in The Hague can potentially play in this. And as you've said at the beginning, even though we might not see actual legal or legally binding results, or at least meaningful legally binding results, given the blockade of the Security Council, what it certainly has already done is create a lot of attention, and we will also discuss that with you, Timela, a bit later on. That public attention might also play a more important role than we international lawyers would traditionally want to recognize. But before we come to that, we have to discuss another aspect of this conflict, and that's the aspect of cyber warfare. So already in the month leading up to the invasion, already as we have seen the buildup of the Russian troops around the borders of Ukraine, there have been reports, lots of reports on cyber warfare, on cyber attacks being launched against the cyber infrastructure of Ukraine. And although this, what we've seen now is a very conservative, traditional military physical confrontation that we wouldn't have expected to occur in Europe again, the cyber attacks continue, and therefore newer aspects of conflicts also play a role. And we want to understand these aspects and their implications a little bit better, and will therefore talk to Lorenz Rubner, who, by the way, has on very short notice agreed to be on this panel and to talk to us about the issue. As the originally announced panelist, our dear colleague Lisa Cohen is unfortunately sick, so we wish her, of course, all the best. And we welcome Lorenz Rubner, who has studied law in Freiburg and completed his practical education, the Referendariat, in Frankfurt. He's currently a PhD student at the EFFV, and he's writing his thesis on international criminal law and autonomous weapons. So he's very familiar with newer aspects of warfare. What role, Lorenz, does cyber warfare play in the current conflict?
Thanks, Benedict, and thanks for including me in this panel on such a short notice. I believe cyber warfare does not play a huge role in this conflict. As you just said, we're seeing a very traditional conflict, a territorial conflict, and I believe that is one of the reasons why we are also taken aback by these actions, because this is a conflict we did not expect happening. Neither geographically within Europe, but generally, we did not expect such a conflict to be happening. So I think there is somewhat of a reality check regarding the relevance of cyber warfare or cyber operations within warfare. I mean, it's pretty clear that both for the world, but also specifically for NATO, and how the German army, but all Western armies are organizing themselves, that we are returning perhaps to a territorial line of defense, territorial conflicts after having 2 decades of a war on terror that is so abstract and loose, that it maybe was easy to kind of also look at cyber warfare as something new and disregard this kind of old type of conflict. So perhaps cyber warfare has been overestimated in the past. On this note, I think that sometimes the term warfare in cyber warfare is not ideal, because we see that cyber operations often work on a different level than this conventional war. So we have both on the timeline, you already mentioned that we had cyber attacks long before the conventional attacks started. We have a different kind of relevance of cyber operations in this conflict, and the severity is clearly very different. So, I mean, when you look through Twitter feeds of military experts, everyone is talking about how many planes were shot down, how many cities were captured, how many tanks are destroyed, how many personnel are in Ukraine, how many casualties. No one is really talking about how important, how Kyiv will be taken by cyber means. And I think when we talk about cyber warfare, we should not confuse it with the traditional warfare. We have a much broader range of activities that we include in this term, cyber warfare, both from kind of time approach and of regarding severity. So we see that cyber attacks did occur more frequently right before the attacks, but they started long before, where we did not talk about a real war, where we did not talk about a crime of aggression, and likely they will continue after this conflict has ended. And we also have a broader range regarding severity, where we see that everything cyber warfare starts with DOS attacks that are purely non-physical, very low level, also including physical relevance, but not on the same scale as conventional warfare. So I think this conflict shows, if it proves to continue in the future, that we have to reassess what relevance we give to cyber operations in warfare, and perhaps reconsider our terminology of cyber warfare as equivalent to conventional warfare.
Thanks, Lorenz. Nevertheless, I think that the possibility of cyber operations doing greater damage in the context of this conflict is nevertheless still realistic in some ways. And I would therefore like to ask you about legal and practical problems that cyber operations, because of their very nature of happening online, pose. So they often, for example, raise questions of attribution. So when we see a cyber operation happening, it is often difficult to attribute that to someone, because the IP addresses are being spoofed or rerouted or what have you. So what role does this play when we look at actors in cyber warfare or cyber operations? Can we even speak of cyber warfare between Russia and Ukraine? I guess you've already answered that to a certain extent. But besides the procedural difficulties that Pierre has already introduced with regard to courts, what do these difficulties of attribution mean for holding a state accountable in the future, perhaps?
Yeah, I mean, generally, I think attribution is one of the main issues in practice regarding cyber operations, because, as you already mentioned, it is factually often difficult to really tie a certain actor to a specific operation. It is easy to conceal your traces, your steps in cyber operations. It's easy to lay false traces. You can even do piggyback attacks. So it's generally we see that it's a lot more difficult to attribute cyber operations or cyber attacks to specific actors and specific states. As I said regarding I already said that I would not, or there is a cyber warfare, so to say, between Russia and Ukraine. But since this whole term is much broader, I think it's not as relevant to whether it has doesn't have the same relevance as talking about, do we have an international armed conflict or not? What we do see is regarding factual attribution that we often link this to who even has the capability. So it is very difficult actually to operate, to execute large and effective cyber operations. So often we see intelligence saying, we believe Russia is responsible for this attack because no one else could have done it. Whether this is enough within a court, very doubtful. So I think we're not there yet, not yet at a level where we know how to practically tie an individual, a group, or a state to a certain action. And what we do see is that we often have these semi-private or private groups operating, which makes it a little bit more, even more difficult to tie to a specific state, and much more so to Putin, as Pierre already mentioned. But this is often more a factual problem than a legal problem, I believe. One other issue is that we often have, or see now, that we have purely private actors. So we see anonymous declaring war on Russia or cyber war. And we see a call for cyber mercenaries, things like that. But as I already said in the first question, I don't think this is too relevant. What we see is that Anonymous, after declaring war, was not really very effective in what they, in their operations, in their attacks, and it's very disputed whether the proof they have shown actually shows any relevant attacks. So I think attribution is generally more of a factual problem at the moment than a legal one.
Mm-hmm. Yeah, I think we've already gotten one question in the chat directly for you, Lorenz, that I think fits quite well with a couple of aspects that you've just mentioned. And that is the question. Oh, it just switched to answer it. This is a question that asks whether if we were to see a more equal conflict and not a conflict of Russia against Ukraine as a David versus Goliath kind of situation, do you think that there would be more cyber warfare? Do you think it would be it would play a greater role if the conflict parties wouldn't be as unequal?
That is a good, but also a difficult question to answer. And I'm not a military general myself, so I'm not really sure what we can expect of kind of a professional cyber warfare. I guess one of the questions we have to ask, or military experts are asking, is kind of this traditional conflict because Russia chose to make it a traditional conflict, or is this really how wars will be fought for decades to come, or centuries? So I don't think we can really say whether or not a pure cyber war or a decisive cyber operation is possible. I think there is more room for cyber operations, but at the same time, Russia is considered to be one of the strongest cyber military operators in the world. So the question begs itself then that if Russia cannot do it or does not do it, who will, and what is the reason that Russia isn't doing it?
Hmm. Thank you very much. As a last point, perhaps, Lorenz, to link this back to the last point that we've discussed with Pierre, you have recently published a piece on individual criminal responsibility before the ICC through cyber operations. And if I'm informed correctly, then at the time of writing, you wouldn't know what would happen shortly after that piece was published, I think. But maybe you could outline for us how exactly I think pressing enter can get you to The Hague, if I remember your title correctly.
Yes, thank you. And I must mention Lisa here, Lisa Cohen, who's sick now, but wrote this piece together with me. We drafted it back in November, so it was quite a while before this conflict or this new aspect of the conflict arose. It's pretty clear that you can be prosecuted for cyber war crimes. And I think this is kind of maybe to make a more general point and to link this back to our therapy session. There's not always a need for new norms. Law, even if it's violated, often it still remains law, and law is always violated. So I think we have to be sometimes careful regarding the question of, is this new technology not governed at all by international law or law in general? Good law is abstract and thus can be applied to even new technologies. And so I think we see this need sometimes to kind of adapt law to something we don't fully understand yet how it will affect maybe practical conflicts. And in this case, I think it has shown that cyber warfare maybe isn't as relevant as we thought it would be. So regarding cyber operations in general, whenever you have a physical effect, it's pretty clear that all laws of international humanitarian law, but also the Rome Statute fully applies. So you can kind of categorize cyber attacks, whether you have a direct physical effect, whether you have secondary effects or no physical effects at all. And only when you have no physical effects at all does it become really tricky to talk about war crimes and violations of international law, because that is an aspect that we haven't fully covered yet, maybe. But especially with these non-physical effects, the question arises whether we need to govern something, whether we need to prosecute someone for a denial of service attack. And the answer, in my opinion, is probably not. Whenever you have a cyber attack that blows up a gas tank or cuts off a water supply from a town and starves a population, this is governed by international law. This is governed by the Rome Statute. So I think the answer to that question is pretty clear. Regarding the practical aspect, will we see someone, maybe not Putin, but someone else in The Hague for a cyber war crime? Probably not. And the reason for that is exactly what I said in the first answer, that it's just not as relevant at the moment. Plus, I'm not sure how far established the know-how at the ICC or national jurisdictions already is to fully prosecute kind of cyber attacks. But perhaps this conflict, exactly because the cyber aspect is a lot smaller, is a good kind of training field for prosecutors to see how they would be able to prosecute cyber war crimes. Yeah, so maybe we will see some responsibility there.
Thank you very much, Lorenz. And with that, I will turn over to our next panelist. You, Lorenz, have just mentioned that, or have just recalled that the title of our session today is an international law therapy session. And even though yours and Pierre's input have not been the most uplifting, if I may say so, we're now coming to an aspect of this whole crisis that, at least for me, has been surprising in a very positive way. We have seen many strong reactions of non-state actors as a consequence of the Russian invasion. And parts of them are, of course, due to the sanctions that Western states have imposed on Russia. But others have also arisen from public pressure, from pressure of civil society. And the reactions range from international corporations pulling out of Russia, over artists with close ties to the Kremlin losing engagements and positions. The most prominent examples here are probably Valery Gergiev and Anna Netrebko. And perhaps the biggest surprise was that even sports associations that are not usually well known for taking a very strong and positive stance with regard to international law, like the FIFA and UEFA, have actually banned Russian teams from their competitions. And in the light of that, we want to evaluate these non-state reactions with you, Timela Mananda. Timela is a research associate and PhD student at the EFFV, and she's writing her PhD thesis on business and human rights, in particular with a focus on times of armed conflict. Timela, given that you have so long observed non-state actors' approaches to international law, albeit with a focus on human rights law and not security law, how have you taken these reactions?
Thank you very much, Benia. So my first reactions were that I was surprised, positively surprised, as you already mentioned, by the strong support of non-state private actors, including businesses, sports associations, and actors from media and arts. Again, because many of them are not well known to be in the forefront of business responsibility for human rights. So it surprised me in the uniformity and also in their clarity. So let's maybe start with, I would like to dissect a little bit this field, and let's maybe start with companies that, although they're not producing arms or providing military services, have a direct effect on the military operations. And as an example, I would like to give is Google Maps, which does disabled the live traffic tracking tools in Ukraine. So it was kind of surprising that this mapping technology had such a big role in the invasion of Ukraine. One research facility in California was able to spot the Russian approach towards the Ukrainian border hours before the special military operation, as Putin calls it, so the invasion of Ukraine officially started and was declared. Now this has raised concerns that this technology might be used by Russia to pinpoint military operations by the Ukrainians and also movements from civilians. So therefore, Google Maps has disabled this tool in Ukraine. So this is an example of a company that has not directly, with a tool not directly involved in military goods or services, having a direct effect on military activities in this conflict. So some corporations do have this direct effect, and we should keep this in mind. Because Alphabet did not give any information if they have done similar steps before. So they have de facto a very, very direct impact on the military operations and on the success of the illegal invasion or the legal defending of Ukraine's self-defense. And we're not regulating this at the moment. So this is an example of uplifting in this case, but giving concerns that we have to take a closer look. Besides these direct impacts, we have seen, as you mentioned, overwhelming support for the Ukrainian people and overwhelming condemning of Russia's invasion. Companies have used words like, for example, Shell, also not very well known for the human rights policies. The CEO of Shell said that they are shocked by the loss of life in Ukraine, which is resulting, their words, from a senseless act of military aggression, which threatens security. So they're using very clear words in how they are interpreting what is happening. Now, this is very clear for us that it's an act of aggression, but why is it so interesting that the companies are using these clear words? Well, if we look at international organizations like UNICEF, for example, they until now have not done this. While they talk about the threats to human life and security, they're calling on all parties of the conflict to limit means, but they have not, in the same clear words as some private actors, condemned Russia's behavior. So we see these clear word uniformity and clarity from a lot of Western companies, but more interesting also from companies from India and even China, starting to release statements that they're observing the situation and thinking about their response.
Yeah, very, very interesting. In particular, that contrast that you mentioned to some international organizations. I have just a couple of minutes ago seen that The Guardian was reporting that the UN have apparently sent emails to all of their employees that they must stop calling this an aggression and invasion and instead use the terms conflict or situation. So that, I think, is a very, very interesting and indeed surprising observation. But What do you think is the legal significance of these reactions? Is there anything, I mean, as I've said in the beginning, we as international lawyers, we don't usually attach a lot of great weight to the actions of non-state actors, at least traditionally. I mean, the field of business and human rights, your field has changed that to a certain extent, but it's also stayed, I would say, relatively safely within that bubble. And now we see such a strong backlash from the private sector side. So what do you think is the legal significance? Can these non-state actors actually play a meaningful role in upholding the international legal order?
Yes, so I think we have to distinguish the de facto influence and the legal responsibility that lies behind that or does not lie behind that. So I think all of we see is also showing that we live in an interconnected world, and we're not only acting through governments. So all of us here are not only represented by governments, but also, for example, as you said, by sports associations. So every one of us who's maybe member of a German or not other countries' sports association is directly connected to the global associations governing these sporting field. So we see that these interconnections are there, and thereby they have the relevance. So what is the legal implication of all of this? We have, as you said, this growing field of business and human rights, and we have since 2011 the guiding principles on business and human rights from the UN, which were unanimously endorsed. And there are laid out responsibilities for businesses for human rights, and interestingly, also for conflict-affected areas. This was actually one of the areas where the late Professor Ruggie put a lot of his attention in underlining that especially grievous human rights violations and IHL, so international humanitarian law violations, take place in times of conflict. And so two things about the legal significance of what is happening now. Firstly, let's look at what there already is. We have the soft law instrument of the guiding principles. Interestingly, this was not only negotiated by states, but also by the businesses themselves. So I would propose we should think about how, if the actions of private entities who in their wording, or if you say like opinio juris style, say they do this because they feel obliged and it goes against their ethics and morals, if this influences how we interpret the guiding principles. So similarly, as we look at the opinio juris of states in interpreting treaties, maybe we have to look at this in the soft law field as well. Secondly, it also shows what ought to be done, because as I said, in this case, a lot of businesses acted accordingly to international law and the idea of peace. But again, we do not know how they will act in the future. And the same companies are committing or contributing to human rights violations in other situations, also in such of conflict. So it shows for me that this is a field that has to be more researched, A, and B, we have to debate further the having binding instruments to ensure that these companies are acting in a way that is in accordance with international law, and especially also in the field of international law of securing peace and maintaining peace. So while I am positively surprised by now, I also have this cynical and a bit of bittersweet part of me that says, A, how do we ensure that this is like the standard, the gold standard? And B, are they really doing this because of their responsibility, or is it because of fear of long-term economic loss, right? So this is also something we see a lot of companies arguing that the interests of the stakeholders in the long term call for now severing ties with Russia because of the economic implications that the conflict will have. So we have to, we can be optimistic, but we should have a really close look and observe this.
Yes, I very much agree with you. Although I would also say that this last point, especially when it's explicitly connected to sort of reputational loss, then it also perhaps again highlights also the power that civil society has by its decisions that it makes when buying certain products or abstaining from buying.
Maybe because I saw the one question on Shell, and I totally agree. That's why I said we have to closely observe. So the question was that Shell has not put its money where the PR words are and bought cargoes of Russian crude at a bargain price. So that's really interesting, because Shell announced that they would sever ties, and only days later it came out that they continued to buy goods from Russia. And interestingly, they then again went back to the first one and said the profits they would make from this would go to the Ukrainian people, and that they had to do this because the Western states are still importing these goods. So we see, of course, we have to be careful in jumping to the headlines these companies issue in their press statements, and really see what is their interest in that, and be observant as consumers, people, and also scholars in what are they actually doing, and what is the reasoning behind that. So thank you very much for this anonymous question.
Thank you, Timila. Maybe as a last question for you, I would like to ask you to look a little bit into the glass bowl of international legal academia. So business and human rights has long been an important sub-branch of international human rights law. Do you think that the reactions that we're currently seeing could lead to business, sports, and culture and the law of peace as a new sub-branch of the international law of peace? Of course, beyond obviously involved actors like the arms industry or certain NGOs.
So I think that although Ruggie put this emphasis when he drafted the guiding principles on conflict, we have seen that this topic was not as highlighted as, for example, I wished it would have been. But we now see, and even before what happened now, that the working group on business and human rights has issued a new report on conflict areas. And what I think is interesting is that we also see new legislation, for example, in the area of conflict minerals that was adopted by the European Union and will enter into force next year. And I think we should also pressure in the new due diligence law that the European Union is drafting currently to include special provisions on international humanitarian law that already binds private actors, but put the spotlight on businesses acting there. And we should also, so what I think could happen is that if you think about due diligence, which is the cornerstone currently in business and human rights, it always also has the component of looking what a reasonable actor in this place of the business we're looking. So if a business A is doing something and we want to assess if it was legal or not, we always, when it comes to due diligence, look at the standard, the gold standard of how should the business and have acted. And of course, incidents and precedences like this can influence how courts and other legal scholars interpret what this gold standard is. So up to now, a lot of companies have said this is not possible. We cannot exit an economic environment that large, right? So now we see it is possible, or it could be possible. Let's see how the example of Shell shows us. Let's see how it will unfold on the ground. But so, of course, this sets precedences to what can be done and sets new best practices if the companies follow through. Also, when it comes to sports associations, right? We always heard we can't do this. We cannot ban country XYZ from participating in sport events or being the guest host state for sport events. And now we see it is possible. So what does it mean for the future? This is, I think, very interesting. And lastly, to tie it back to the courts question, we do see tightened the chance of tightened binding responsibilities on corporations. If you look, for example, at the Lafarge case, where this French cement company now is under criminal investigations for supporting or contributing to ISIS war crimes.
Yeah, thank you very much, Timela, for this cautiously optimistic outlook is what I would perhaps summarize it with. Turning now again to perhaps a bit more discomforting aspect of the current situation. Many people are concerned about the threat of a nuclear war because of the newly sparked confrontation between Russia and the West. And while some of the people on this panel, including myself, have not experienced the times of the Cold War, we have all very well heard the many voices that have evoked that fear from the past again. Especially because President Putin has made quite explicit references to the Russian nuclear arsenal in the context of the conflict and as a reaction to Western sanctions. So we want to discuss what the involvement of nuclear powers in the current crisis means with Professor Hans-Joachim Heinze, who is professor for public international law at the IFFV. Professor Heinze, which role do nuclear weapons play in the current conflict?
It's a pity. Nuclear weapons do play an important role. And we have to talk a little bit about the European security structure at the end of the Cold War. At the end of the Cold War, we were talking about equal security, and the Social Democratic Party in Germany was very much interested in that topic of equal security. And the legal basis and the military basis for this principle was the existence of nuclear weapons on both sides. In 1994, we were in the very good situation that the successor states of the Soviet Union were not any longer interested in to keep nuclear weapons on their territories. And especially Ukraine decided in 1994 to join the Non-Proliferation Treaty. This means they were ready to get rid of the nuclear weapons, to give it back to the Russian Federation. However, it was a kind of deal because they have got the promise of three nuclear powers, a promise of the Russian Federation, a promise of the United States and of Britain, that they, let me quote, that they reaffirm their commitment to Ukraine to respect the independence and sovereignty and the existing borders of Ukraine. It was a kind of promise. And Russia, United Kingdom, and the US, I quote again, will consult in the event a situation arises that raises questions concerning these commitments. Okay, what does it mean, a commitment? Is it a guarantee? Is it only a political statement? However, at the end, I think we can agree it was legally binding because the document was signed by the political leaders of the three countries, among them Boris Yeltsin, the Russian president. He signed it on behalf of the Russian Federation, and therefore it's still legally binding also to the Russian Federation. It's quite clear Russia is going to violate that obligation because they put now in question the borders of Ukraine, they put in question the existence of Ukraine. Therefore, what happens now? Is it a guarantee by the two Western powers to defend the Ukraine, or is it an obligation to enter only in consultations? Is it an entitlement or an obligation of the two Western powers to apply the principle of collective self-defense? I mean, collective self-defense, that is a decision of the countries to help a country which is a victim of an aggression. And we can see it in the case of Kuwait. 40 countries were ready to exercise collective self-defense against the aggression done by Iraq against Kuwait. That means collective self-defense is one possible way to give power to that commitment. However, I cannot see an obligation to exercise collective self-defense because we can compare the situation a little bit with the obligations of NATO countries. We know, according to the NATO treaty, in cases of aggressions against one member state of the NATO treaty, then the other countries consider this aggression against one country as an aggression against all countries. And that means at the end, they can enter in a situation of collective self-defense. But it's not an automatic reaction. No, the first step are consultations. What can we do now to protect one of the member states of NATO? That means there's no automatism that we get into a military situation in any situation of an aggression. Perhaps sanctions are also an answer, which is a consequence of that commitment. And therefore, avoid automatic reactions. And we have an example within NATO. I mean, during the conflict between Turkey and Greece, there was no involvement of NATO at all. NATO decided, okay, we cannot do anything in that situation, with exception of consultations and recommendations to the parties involved. Okay, now we know the two Western countries are guarantee powers of the independence and the keeping of the existing borders of Ukraine. And now we have to ask ourselves, what is the consequence concerning the principle of equal security? Yeah, it seems to me, obviously, there's a difference between the security of countries which are in possession of nuclear weapons and non-nuclear countries. And that gives the nuclear powers a special status in international law. And I would argue, yes, this special status is recognized by international law. And we can see it in the case of the United Nations Security Council. I mean, we are going to leave this principle of sovereign equality because the Big Five, they have a special status within the United Nations. And this was accepted by 193 countries, which are member states to the United Nations. Therefore, equal security, I mean, I have some doubts that we really can accept the principle of equal security in connection with nuclear power states and non-nuclear countries. And now that leads to the next step, that leads to the non-proliferation treaty. The non-proliferation treaty is the idea is, okay, to make sure that only the Big Five and 3 other countries, that they are not bound by that obligation not to go for nuclear weapons. And if we take in consideration, obviously, there is no equal security for those both categories of countries, the nuclear powers and the non-nuclear powers. That means there's now a challenge that many countries may think, okay, perhaps it's better to leave the non-proliferation treaty and to go for nuclear weapons, because if we have nuclear weapons, nobody is going to attack us. And that's a terrible consequence of this behavior of the Russian Federation. And I can see a certain tendency among some countries to withdraw from the non-proliferation treaty, especially in Asia. But there may be also a tendency in Europe, because there's also some criticism concerning the non-proliferation treaty. Many countries argue the existing control mechanism is not up to date, because we have new technologies concerning nuclear weapons. And those nuclear technologies, the new technologies, cannot be taken under control by the Atomic Energy Organization. That means unpleasant consequences of the situation concerning nuclear weapons. I'm sorry about that. Okay.
No, thank you very much for this insightful input into, I think, the role that physical and military power still plays, even so many years after states have actually solemnly proclaimed that it should not play such a great role anymore in 1945 with the founding of the United Nations. But perhaps that is a good cue, that realization that physical power is still so important in international relations, and that reality check to turn to our last input. And that is the question of whether it's time to recalibrate international law. So the system known as the post-war, or formally known perhaps as the post-war international legal order, has always been an imperfect system. And we have, of course, always seen violations of certain degrees and certain kinds in the years between 1945 and now. The brazen invasion of an independent and sovereign state by another state that we have seen in the recent days is, or at least feels like to many, a new dimension of international law violation. And that perhaps, it's perhaps safe to say that this is the most fundamental challenge to the international legal order since 1945. And in the light of all of this, we want to ask ourselves the question what that means for international law and what that might mean for our discipline. And we want to discuss these questions with Maximilian Bertamini. Max is a research associate and PhD student at the EFFV, and he writes his thesis about international space law, but with a strong focus on the concept of sovereignty in international law and international relations. Max, which particularly noteworthy observations would you currently make about the situation? What does all of that mean for international law as a whole?
Well, thank you, Benedict, first of all, for the introduction. And I must perhaps disappoint you, because these questions that you've presented me with are perhaps one size too big for me to bring answers with which everybody is happy and with which are consistent in and of themselves. But in terms of observations that can be made about the current situation, I think there are a few points that come to mind which may have implications for the developments and the role that international law has to play in the future. I guess the first one would be, taking up what you said in the introduction, is that currently it seems to be power and not necessarily international law which sets the agenda of what is happening. I think we have very strongly seen that in the Russian invasion, which has apparently paid no regard to international law whatsoever. And only very weak attempts have been made on behalf of the Russian president to in some way articulate what is happening in the terms of international law. But I think also from the other side, if we look at the reactions that the rest of the international community, including private entities and civil society, have come up with, I must say that given the intensity and given the speed with which, for example, sanctions were imposed my impression is that the leaders who got together did not necessarily first think about what the international legal protocol is, which should be followed here, but the reaction was probably that pressure is needed to just stop what is happening, and only after the fact international law articulations have surfaced and are surfacing, trying to justify what is happening as a reaction. That being said, of course, the reactions to the Russian invasion are much easier and much more solidly justifiable in the terms of international law. But just in terms of what is happening right now, I think that it's a case of action and reaction, and the case of power meeting power, and only after the fact it is tried to articulate what is happening in legal concepts. And I think this might be an observation which provides us with a reality check of the role, or for the role rather, that power still plays in international law, and whether international law even has answers for injustice which is flexing its muscles and which is exercising power against the law. That will be sort of my first observation to make. The second one touches on the reactions of the non-state actors. First and foremost, Timela has talked about this more extensively, so I will try to keep this point shorter, but I think what we're witnessing now in terms of reactions to the Russian invasion, both from the international legal actors, the states, but also in terms of private entities and civil society, is an unprecedented way of reacting to international law. And I think, not to international law, but to violations of international law. And I think that this, what this presents us with is a taste of what enforcement of international law would look like. Lawful enforcement, that is. I mean, international lawyers are often posed or faced with the question of whether or not international law is a toothless tiger, as it lacks the possibility to be effectively enforced. And while, of course, this is a big question, if and how international law can be enforced, I think the current situation and the reactions that the international community gives to the Russian invasion may be a starting point to reopen this book on international law enforcement, including the role that non-state actors might play in it. At the same time, I think the reactions we're seeing raise questions regarding the validity of international law below the prohibition of on the use of force and perhaps even an armed attack. I think these reactions that we're seeing by the international communities are a reaction to the most severe violation. And while the reaction gives hope that this is a red line which still stands, it also raises questions about the validity of everything that is below that threshold, because we have rarely seen such reactions to any violations of international law below that threshold. I mean, the prohibition on the use of force gets violated quite regularly, if we're honest. I mean, there are severe human rights violations going on. There is interference in elections. There is misinformation campaigns. So perhaps a lot of prohibited intervention going on quite regularly. And while there is some condemnation to be found, the reactions are nowhere near as intense and as forceful as what we're witnessing today. And I think we might have to ask ourselves as international lawyers what this tells us about the validity of the international order as a whole. Okay, so that shall be the second point. And the third one, maybe this goes back to one question that has also been raised in the chat, whether or not international law could have prevented this, or whether international law is doomed to only react to existential threats, one could say. And my first impression would be that historically this is the way it has been. I mean, whenever there have been order-changing developments in international law, they have come as a reaction to some sort of existential threat, be it in the form of a major conflict, of a military conflict, that is, be it in the face of a major threat through terrorism, for example, through climate change. I mean, one can recall the Peace of Westphalia, establishing equality of states and independence as a reaction to the 30 Years' War. One can recall the League of Nations with the prohibition of war and with the establishment of the PCIJ as a reaction to the First World War, the UN as a reaction to the Second World War, and so on. And I wonder if international law, as it could not have prevented these things from happening, whether it could have prevented the invasion of Ukraine. I think potentially it could have, and I'll maybe get back to this point later, but I'm not sure if an international order which could have prevented this this invasion from happening would be one that we would be willing to pay the price for, in terms of what we would need to concede in order for such an order to exist. But I can get back to that later. The last point that I want to make in terms of sort of first observations here is that I think most of us, perhaps all of us, have grown up, as you said, Benedict, in a world where we could just take for granted that international law works, and that it is observed, and that no major threats are posed to the international legal order as such. And I think this invasion of Ukraine could be this a sort of stovetop moment for us. And what I mean by that is, you perhaps all know the sort of parental wisdom that if you tell a child that that fire is hot, that it shouldn't touch the stovetop, it knows, but at the same time there is a difference between just knowing and actually having felt the pain, actually having touched the fire. And I believe that this invasion that is unfolding right now might be this stovetop moment. It might be us now touching the fire, feeling what it looks like when international law is not working as it should, and what we're up against, what we're trying to prevent. And I feel that orders that try to establish peace might just work best when the closer they are to this stovetop moment. And while this is a grim prospect, because it means that history might repeat itself, the farther away we move from this moment where we felt what we want to prevent in the future, I think this might be the reality we are dealing with. At least I, for now, don't have an answer on how we should proceed differently.
Yeah, thank you very much, Max. You have chosen the title of recalibration of international law for your input. And to conclude our discussion amongst ourselves here, I would like to ask you what you think which recalibrations of international law are realistic, or what can be achieved, and what are perhaps the risks for the international legal order now in the aftermath and in the adaptation of the legal order, be that through formal changes of law or be that through subsequent practice or whatever have you. What needs to be kept in mind, and what is realistic?
Well, I mean, I can only speculate here, of course, in terms of what is realistic and what will happen. But I think we can think about recalibrating international law in three directions, I would say, and between two sort of poles between which international law can move. And these poles would be, on the one hand, the realization that power in terms of dominance, be it militarily, financially, culturally, and whatever you can imagine, is not only a reason to have international law, and so something that needs to be regulated by international law, but also something that actually moves and motivates actors on the international level, and that power should be taken into account when dealing with international law, and we should employ a realistic perspective. And the other pole would be that that we do not want an international legal order which is only dominated by power, but which is also characterized by considerations of equality, by a rights-based order, by an order which does not just bow to power. And so between these two poles, I feel that recalibration is necessary and possible, and the current events might lead international law to develop more again into the direction where we may need to take into account that power just is a reality, and that it must be kept in mind that power can be used to just transgress international law. And so And this leads me to the potential recalibrations we need to undertake as international lawyers. And I would say the first one would be to close loopholes in the existing legal system. I think what led up to the Russian invasion, for example, was a huge disinformation campaign, both in Russia, for example, but also in terms of Russian foreign news outlets like Russia Today spreading misinformation in countries abroad. And of course, we have the freedom of expression, and we have human rights protecting media outlets and journalism. And yet, the international legal system has good ways of addressing breaches of these freedoms, but it doesn't have as, let's say, as established or as developed means and mechanisms to react to just simple misuse of these freedoms. And so I think we really need to be thinking about how to react to actors turning the law that we think is the right law to have against ourselves. And I think recalibration in that regard is one thing that needs to be going on. The next area where international law needs to be recalibrated, I feel, is on the level of the United Nations. I think if the events that we're seeing now do not lead us to reform, for example, the Security Council, I don't know what will, to be honest. A P5 member just blatantly violating the international legal order as such, every single principle of the United Nations, and then having the audacity to use its veto power in that same order to just keep responsibility away from itself is just a slap in the face of everything that the United Nations Charter stands for. And I think if the rest of the international community, even in light of this slap in the face, does not have the guts to honestly think about reforming the system again, and perhaps even looking past provisions in the UN Charter, which would enable Russia to veto also, or let's say, prevent changes to the Charter, then I don't know what will. Of course, changes to the Charter require not only 2/3 majority, but also the voices of all the permanent 5 members. But I think it is desperately necessary to do something about this very unequal and misusable security architecture on the international level. Perhaps even give the powers of the Security Council to the General Assembly. I mean, why not? I think the reactions in the General Assembly to the Russian invasion have shown that we can rely on the community of states to want peace. I mean, 140 votes in favor of the resolution proposed, against a few abstentions, and 5 votes against is a clear sign that the international community represented in the General Assembly can probably be trusted more than the Security Council can. And then on the very general level, in terms of what it takes to keep the international world at peace, and which role international law can play in there, I feel that this question is perhaps too big to discuss now, and the answer would also probably be not very uplifting. I think we can also obviously talk about keeping great powers in an equilibrium. I think in terms of keeping power at an equilibrium, we need to be talking not only about military power, but as the reactions of the West, if we can call it that, and of, for example, private companies have shown, financial power is something to be taken very seriously in this context as well. And yeah, the price that I've been mentioning in the beginning, that we might need to pay in order to have an international order that is at an equilibrium and that is able to prevent conflicts from arising, might be one in which we pay less regard to self-determination and to universal approaches, for example, based on human rights, that say how the world is supposed to function. And I think that is a very high price to pay in order to have peace, but at the same time, peace is obviously something very valuable to have, and this is something that needs to be negotiated and discussed on the global level. I personally would not be willing to pay human rights and self-determination as a price to have peace at every cost, but I don't know, maybe somebody sees this differently, but I think this is essentially what it takes, since the interests between the big powers are so different in that regard.
Thank you very much, Max, for those remarks and for zooming out with us a little bit and for letting us have a bit more of a general and detached look on that most certainly imperfect system. And I very much agree with you that the international community must come together now and try to recalibrate as much as is possible. We have questions in the Q&A fields, and one question relates to a relatively small yet perhaps meaningful recalibration of the international system. And that's a question explicitly to you, Pierre. As you were referring to creative ways to bring this conflict to courts, nearly 40 international lawyers 4 days ago proposed the establishment of a special tribunal that would only have jurisdiction over the crime of aggression in Ukraine. And one can certainly think of special tribunals that have in the past been established by the international community to address particular situations. So do you think that something like this is likely to happen? And if so, do you think it's a good idea, or could it do more harm than good?
It connects a bit to another question that I saw was also posted on the chat. So just to make this clear again, so the crime of aggression for which this tribunal is proposed now is a bit different. That goes to Linus Bergauer's question, because in the Rome Statute, specifically in Article 15 bis, paragraph 5, it says that for aggression, the court shall not exercise jurisdiction if a state, for individuals where a state is not a member, right? So if a state is not a party to the Rome Statute, then over nationals of that state or crimes being committed on the territory of that state, the crime of aggression shall not be dealt with by the court. That's very different to the other three. And that is the case because the crime of aggression was so contentious in the first place, and that was the best compromise that could be reached. So that's the question that Mr. Bergauer asked. And now linking this to your question, Benedikt, that's where the frustration comes from, right? So while in theory, we could see cases against genocide, crimes against humanity, and war crimes against Russian individuals before the International Criminal Court, we cannot see the same with respect to the crime of aggression, in particular, if you think about the political leadership, Mr. Putin in particular, right? And that is because of this Article 15 bis, paragraph 5. And the only way to overcome this would be a Security Council resolution, and that we will not have because of a veto that the Russians will certainly use. So I can understand the frustration that comes from this proposal, and lawyers who have proposed this are very influential lawyers, Dapo Akande and Philip Sands and so on and so on. So I don't want to say this is not a good proposal. It is, I think, politically an important proposal, and it has found a lot of support. Of course, one has to, again, reality check, ask what is legally gained by this. I don't know whether it has a risk, because that was also part of your question, but what is really gained by it, and how is the situation different, right? So, I mean, if we compare it to, let's say, the Rwanda Tribunal or the Yugoslavia Tribunal, then of course that was created through a Security Council resolution under Article 41, Chapter 7 resolution under Article 41, for which the Russians would use a veto, right? So we can't see the Security Council creating such a tribunal. And so what we then would need is some kind of international treaty to establish such a court, tribunal, whatever you want to call it. And the question is, of course, what is gained by this if that tribunal is created through a treaty without the consent of Russia, and Russia will not give consent. So I am not so sure whether this really will bring the desired effect. I very much understand the desire to bridge this gap that we see in the Rome Statute, but I don't know whether this new tribunal is really helping it. And keep in mind that when, I think the comparison is a lot to the Nuremberg and the Tokyo trials, right? But that was also a bit of a different situation in the first place. But secondly, also it was a time before we had something like the International Criminal Court. And I think, if I'm not wrong, I think Germany and Japan gave their consent in the end. I mean, they were first forced to give their consent into these courts as well. So I think it would be a different situation. I don't know whether it has risk. It might have a very positive political signal that it would send, but whether it really bridges the legal gap to create such a new tribunal, I have my doubts.
I think I can just add one sentence, because Pierre just said that you don't see any risks. I do see the political risk that if you establish a tribunal basically to just prosecute one single person, this is a huge political bargain. And spending millions of dollars and then not getting any result, that would be a huge failure. And so, I mean, you're already seeing these problems with the ICC, that we don't have enough convictions, etc. So I think there is a huge risk you're betting on that. And as you already said, perhaps the better avenue would be to kind of use this, and this is also something Max said, use this momentum to kind of perhaps change the Rome Statute and to use this already permanent court for the future.
Yeah, thank you very much, Pierre, for your answer, and thank you, Lorenz, for that addition. We have another question to Jochen Heinze in the Q&A, and that is, what about sanctioning, and how would that be possible? The threat of using nuclear weapons, which is clearly illegal in line with the 1996 advisory opinion of the ICJ.
Yes, good idea. However, the advisory opinion is legally non-binding, and therefore I have my doubts that we can find a way to put this issue of threat with nuclear weapons on the table, because every nuclear power is going to argue it's only deterrence. We are not going to use it, but we are protected because we have those nuclear bombs. And now Putin's statement is a little bit different. However, the background is, okay, we have a special status because we are a nuclear power state, and therefore we have a special status, and this is accepted within the system of the United Nations. Therefore, no, I cannot see that we can put that issue of threat with nuclear weapons on the table, and there's also no body which can deal with such a situation. But concerning the question we were talking about, perhaps the solution is to establish a non-governmental court, like the Russell Tribunal in the past, because now the non-state actors have such a power, the public has such a power. Perhaps we can solve all those problems with state-founded courts by establishing a non-state tribunal to deal with such crimes.
Okay, thank you very much. I would like to encourage our viewers, as the panelists have all told me that they have a couple of more minutes, so we can go a little bit over time, and we still have a lot of people following this. So if you have more questions, then please post them in the Q&A. I can't guarantee that we will be able to answer all of them, but nevertheless, the panelists have a little more time, so we're going to continue this a little bit beyond 6:30. The next question is another hypothetical on institutional changes within the United Nations. And given that it's not addressed to anyone explicitly, I'll just pose it to all people on this panel. Could the United Nations General Assembly not establish a court as a subsidiary organ of itself? So could the United Nations General Assembly, that's how I understand this question, instead of creating human rights bodies, as it has done, for example, in the past, couldn't it create a body that's explicitly dedicated to this situation? Perhaps a court, a tribunal, or any kind of fact-finding institution, etc. Does anyone of you have thoughts on this?
I guess the fact-finding makes sense. No, we have something similar for Syria, of course, since a few years, and that is a mission to kind of help to enable criminal investigations, I believe at national, regional, and international level. And something like this, I could imagine, could actually make sense for definitely makes sense for Ukraine as well. Yeah, I don't know whether this has really been discussed yet. I think I've read it somewhere, in the literature it has been discussed. I don't know whether the Ukrainians have suggested it so far. I mean, with the court, if I understand your question as well, under the UNGA, I'm a bit skeptical, right? I mean, keep in mind what the powers of the United Nations General Assembly are. They are of recommendatory in nature. They don't have any legal force. So for the Security Council to create special tribunals, as I mentioned before, in the case of Rwanda and Yugoslavia in the mid-90s, that seemed to make sense to me. Whether the General Assembly, without the power to have and to do anything legally binding, which is what we would want at the end as an outcome of a court decision, or whether that makes any sense, I'm a bit more doubtful. But fact-finding mission along the lines what I see now has also been stated here in the chat, as we have seen for the Syria situation, I think that could make sense, but maybe others have an opinion too.
Yeah, maybe to add to that, I agree that in the current system of United Nations we have now, any subsidiary body must be within the scope of the tasks given or mandated, General Assembly mandated by the Charter. And if you think about the Uniting for Peace resolutions, which we have since 1950, if I'm getting this number correct from the top of my head, and used 11 times by now, it was also a decision on where is the how much power can the General Assembly have vis-a-vis the Security Council. And I think when it comes to binding decisions, I mean, the Uniting for Peace resolution is not a binding one, and even that was politically difficult to establish. I think within the current system we have right now, without reforming the hierarchy or the relationship between Security Council and General Assembly, having a binding instrument would be problematic. I think this goes back to the flaws of the system we have built after World War II, which had political reasons why it is the way it is. And maybe this is a good moment to add one thought I had about a fallacy we humans tend to always have. So I think we have the fallacy towards the status quo. So it's difficult for us to imagine anything different from what we have right now. So I think before the United Nations, or before World War II, it was difficult for people to imagine having something like the United Nations we have now. And for us as living now, it's difficult to imagine what could emerge in the future. So I think to add on this, that as a lot of legal scholars, I think as a discipline, we tend to be especially vulnerable to this fallacy because we are trained in the status quo of the law. So I think, my encouraging hope, also going to the direction of the others, would be that we have to stop falling for this fallacy and really think about what can come in the future. And I think this underlines very well with Fukuyama's book he wrote, and then he himself said he was wrong about the end of history. And the similar, I would say, we're not at the end stage of law, international law. Something will come in the future, at one point, that will be different to what we have now. And we have to use our resources to make sure that it's something that we, a system where we want to live in, right? So we have to uphold the values we would like to see in the system. And as Max said, think about economic power we have, and as society, as individuals, and as states, to ensure this.
Yeah, thank you very, very much, Timela, for this very important point that is certainly very fitting in our little therapy session here, and that is something that we should remind ourselves of as international lawyers, especially in moments of desperation, like the one now. I would like to use one of the questions that was posted in the Q&A now as a sort of wrap-up question, as a last question. And that I would like to pose that to everyone with the question for very short prognosis. So I would like to hear from you your prognosis, and if you could answer briefly, given the time, I think I and everyone involved would certainly appreciate that. So the question is, given that the major enforcing entity in the current legal system that we see is currently blocked because of the veto, and we've explored that in a couple of contributions here today, there is a need for, as you've called it, Max, recalibration, and you've already said, or you've already hinted at the potential of this very dire situation now to spark an actual reform in the international community. And the question was, what do you think is the likelihood of a large number of nations to rally behind international law and behind a reform of international law now, and to perhaps revamp the system of international security that has, at least for now, reached its limits in its current form? Who wants to start with a short prognosis?
I mean, I can take it first if you want to. So I think the likelihood depends really on the P5. It is up to them to agree or disagree, of course, in combination with at least 2/3 of the other members of the United Nations, to any changes of the security architecture. With regards to Russia, I think that it would definitely be possible, or at least conceivable, let's say, to ignore the Russian position, for example, based on the fact that the Vienna Convention on the Law of Treaties allows for the parties to a multilateral treaty to suspend parts of that treaty vis-a-vis a party who has manifestly violated the treaty. And if Russia's invasion of Ukraine was not a manifest violation of the UN Charter, I don't know what is. And so I see that Russia's consent to any of this could be circumvented potentially. I don't know if the Chinese, if the US-American position as the two other like individual superpowers on the globe would be as easy to circumvent, or if we would need that. I think there might be resistance from those sides, which is not as easily to brush off. So I think while there is a considerable momentum, and I personally would be in favor of such a development, I think whether it happens really depends on too few states.
Thank you, Max. Professor Heinze.
It seems to me that the situation now is not a failure of international law, it's a failure of diplomacy. I cannot understand that we always talk about sovereignty and borders. Hey, we are confronted with universal challenges. COVID is a very good example. It does not stop at state borders. Therefore, we have to use international law as a means of cooperation, not as a means of sovereignty. We cannot reach our goals concerning climate change by insisting we are a sovereign country. No, we need cooperation and we need diplomacy. I mean, our our reaction was legal, okay, but was it very useful? And therefore, no, it's not a failure of international law. Thanks.
Thank you very much. Pierre?
Yeah, I've been thinking, when I listened to Max, it was very interesting, and I've been thinking about it, but I mean, your question is a bit different now, because Max, if I understood him correctly, was talking about recalibration of international law, right? So, and what is recalibrate? Kind of if a system goes off course and you need to kind of find a new reference so that you adjust it again, that it goes in the right direction. And now we're discussing whether the enforcement is the problem. So, and then maybe this is a way to combine a bit what Professor Heinze and Max said. So, international law per se, I don't know really whether it is a problem. I tend to agree with Joachim Heinze, because I mean, someone asked, shouldn't we make the threat of the use of force already forbidden? It is forbidden. Look into Article 2.4. You know, I mean, it's not the problem that the rules that we have are not the right rules. I think they are. And that's why I think that would also be my response to Max a bit. I don't think we need the recalibration of international law in substance. We really need more recalibration of the enforcement mechanisms of international law. And that is interesting now. I mean, Max, I think, just said maybe now is the historic moment where we could reach it. And that could be, I don't know, I think really the international world has been shaken. And maybe they are willing more than they were before to change the setup. I mean, we have a system from 1945, right? Now we're in 2022. It has changed. We should also change the system. I think a lot of people are in favor of it. But in which direction is the question, right? I mean, for instance, most of the proposals we hear about the Security Council reform are to add more vetoes. Yeah, or to add at least more permanent members, you know, and I don't know whether that is the solution. So I can see that maybe we have a historical moment now, and we have the responsibility to also make something good of it. And maybe this something good of it, as hard as it is to imagine at the moment when we see people dying, to think of anything that could be good about this eventually, could be to really restructure the United Nations in that way and the enforcement mechanisms. But again, I don't think we have to recalibrate international law. Maybe really, as you hinted in your question, it's more about recalibration of how do we make sure that it actually is not breached.
Thank you very much, Pierre. Lorenz Timela?
Yeah, I really want to agree with Pierre. I don't think international law is dead. I don't think it's the problem here. I don't see a possibility of a reform of the United Nations. I think as difficult as it is to say, we are nowhere near the severity of what the Second World War was, or the First World War, in gaining this momentum to really make a fundamental change, a new world order or security architecture. But I don't, the point I want to make is I don't see international law to be the problem. And really briefly, I think it's clear that not every violation or never just a violation of law kind of challenges the validity of law, because every law is broken, violated. What challenges the validity of international law or law in general is when there is no reaction to a violation. And as Max already pointed out, there is a very strong reaction here. It's not legal, but there is a hugely, very, very unprecedented strong reaction. And I would make the argument that the response to a violation of law does not have to necessarily be legal in nature. So what we are seeing is that the entire world is reinforcing international law through economic sanctions, through political statements. And this, I think, is making international law even stronger. So I believe at the moment, international law is almost stronger than it was 2 weeks ago.
Yeah, so I have a lot of thoughts on the question, but to recap, to make it short, and to also focus on the topic I'm here to cover, I would say that the future must lie in thinking international law on more scopes, thinking about economic power as well as even same with the same strength as military power, right? So I think a lot of people have always said the idea of integrating human rights clauses in investment treaties, for example, is like a niche topic and not so relevant. But we see here that economic power and economic relationships are very, very tight together with security and diplomacy and peacekeeping, or using economic power to strengthen peace. And so I think that my hope would be that we have to think about actually strengthening global governance in a coherent way, right? So it's not that human rights is here and investment treaty law is here, and then we have international humanitarian law and all of this in fragmented areas, but all of this ties together. And strengthening human rights means also strengthening peace, because we have to be clear that all of what is happening now in the Russian invasion is also possible because Putin has within Russia violated human rights, free speech, opposition rights, and so on. So I think that besides these reform questions on the institutions, we really have to think about these topics interlinked, because they influence each other. And finally, I would say that we have added so much globalization when it comes to economic actors, right? So our global world is so much interconnected when it comes to businesses, corporations, and other entities. And we have failed to connect this with governance structures on the international level. And I think by doing so, we can really also add to the peace architecture in a broader sense.
Thank you very much, Timela, for that last input. Thank you very much to all the panelists for your insights, for sharing your thoughts and concerns with us. Thank you, everyone. Thanks to all the participants who have really stayed with us, even though we went so considerably over time in large numbers. I personally can say that I've really, I appreciate this conversation a lot. In particular, those, albeit few, but those optimistic, those hopeful outlooks. And I really hope that we today with our discussion could spark some ideas, could spark some new thoughts among us as panelists, but also among the participants in the audience. Thank you very, very much. And yeah, I think that the situation will certainly keep us all very concerned as international lawyers. And I really do hope that eventually, even though this could still be quite far away, that eventually this will bring about some changes for the better. Thank you very much, and have a good evening, everybody.